Good afternoon. My name is Michael Cooper, and I am the president of this association. And it's my privilege to welcome you to this opening plenary session of a 3-day conference on access to justice for poor people. You have traveled to this meeting hall from 14 different countries to discuss this subject. What is it that has persuaded you to come thousands of miles from such distant lands as Australia, Japan, South Africa, and Chile, to exchange experiences and views on the delivery of civil legal services to poor people? What do we have in common that leads us to believe that a global forum on access to justice issues is a worthwhile endeavor? The answer, I suggest, has 5 elements. First, however different the economies of our countries may be, each has a significant population of poor people. One of the great ironies and paradoxes of our time here in the United States is that during the recent years of continuous economic growth and prosperity, with more and more individuals accumulating great and in some cases almost unimaginable wealth, still a significant stratum of our society continues to live in poverty. The New York Times, in an article this past December, ran a feature story under the following caption: "Poverty rate persists in city despite boom." The article reported that 1.8 million New York City residents, a full 1/4 of the population, live below the poverty line. That number is as great as, or perhaps greater than, the number living below the poverty line during the last recession in the early 1990s. The prevalence of poverty in the United States is not confined to New York City. The United States Bureau of the Census reported 4 years ago that the share of total household income of the poorest 1/5 of our country's population had declined 15% over the previous 2 decades. Now, I cannot cite statistics for each of the countries represented at this conference, but I am confident that each has a population of poor people, at least of sufficient number that their legal needs cannot be overlooked. The second characteristic we share is the fact that the basic needs of our respective populations of poor people, needs such as shelter, food, family unity, medical care, are protected by legal rights, the enforcement of which normally requires the services of a lawyer. The poor tenant threatened with eviction, the family that is denied subsistence benefits, the physically disabled individual who cannot enter a public place of accommodation because it does not accommodate a wheelchair. Each needs legal assistance in dealing effectively with the people who threaten or infringe their rights. The third element in this equation that brings us here is that the resources available to address the legal needs of the poor, at least those that are being devoted to addressing the legal needs of the poor, are woefully inadequate to the task. That is true of both governmental and private resources. Speaking only of the United States, the Legal Services Corporation, the principal federal source of funds for civil legal services to the poor, has seen its funding by Congress decline during the past decade, both in actual dollars and, of course, even more when adjusted for inflation. And Congress has imposed severe restrictions on the freedom of LSC grantees to handle certain kinds of matters. Funding of civil legal services is also provided in New York by the state and the city. But these funds are made available reluctantly, belatedly, unpredictably, and in amounts that are far too low. To make matters worse, state funding is a political football. I should interject that I've learned that, to my dismay, as well as outrage, in my efforts chairing a commission appointed by Chief Judge Kaye to try to find sources of permanent funding. And of course, when I went to Albany, the Senate said, don't speak to us, go to the legislature, the Assembly. The Assembly said, you know, if the governor proposes it, we'll pass it in 15 minutes. And of course, the governor tells you to go back to the legislature. The Senate and Assembly each year jockey to include in their respective favored items in the state budget, and legal services providers are left to receive the scraps off the table. They've had to curtail their programs and cut back on staff as a direct consequence of inadequate legal funding. I look forward to learning whether you have been more successful than have we in persuading your respective governments to fund legal services. And if you have, whether and what we can learn from your success. The private bar in New York City and elsewhere in this country devotes many thousands of hours to doing volunteer pro bono, frequently in collaboration with legal services staff programs. The administrative board of the New York courts passed a resolution last year exhorting lawyers in private practice to devote at least 20 hours a year to pro bono volunteer work. And the bar of the state has been very generous in its response. There is undoubtedly more that the private bar can do to support legal services by way of both monetary contributions to legal services providers and increasing the number of volunteer hours. But it is simply impossible in this country, and I suspect in most other countries as well, to expect volunteer lawyers to fill the entire gap between needs and resources. The final two traits we share that have brought us together in this meeting hall today are a common commitment to find new ways and to improve existing ways of effectively addressing the legal needs of the poor, and a belief that each of us can learn something from and hopefully contribute in turn to other conference participants. While the challenge of providing legal services to the poor is global, approaches and resources differ widely from country to country. In fact, one impetus behind the convening of this conference is the fact that the United States, the wealthiest of nations, appears to lag far behind many other nations in the resources, public and private, that are devoted to civil legal services to the poor. In calling for an expanded constitutional right to counsel in civil matters, United States District Judge Robert Sweet noted in a lecture given from this very podium 3 years ago that England has recognized a common law right to counsel in civil matters since the 15th century. That France, Germany, Switzerland, and other European countries recognize a statutory or constitutional right to counsel. And that the European Court of Human Rights has interpreted the European Convention on Human Rights to require that member governments provide counsel to the poor in civil cases where representation by a lawyer is necessary to afford effective access to the courts. Judge Sweet, in that address, cited an article by one of our conference participants, Earl Johnson, Jr., Associate Justice of the California Court of Appeal. These European examples stand in contrast to the willingness of courts and legislatures of this country to recognize a right to counsel in only a very small category of civil cases, at least so far. Many other nations have been more generous in funding legal services to the poor than has the United States. I can give you an example that's really quite close to home. The funding provided by Ontario and some other Canadian provinces has greatly exceeded on a per capita basis the funding provided in this country, despite the similarities of our legal systems. Unfortunately, the news from abroad is not all good. There are reports that governmental funding of civil legal services to the poor is being cut in a number of countries as the welfare state shrinks. Other nations are looking to pro bono legal services as a potential means of providing additional resources. However, we in the United States, who probably have the most extensive experience with pro bono services, are increasingly recognizing, as I've already stated, that private lawyers acting as volunteers can play only a supporting role, albeit a critical supporting role, in providing civil legal services for those who cannot afford to pay counsel. In short, this conference is being convened at a difficult time for legal services. It is a time when new approaches must be explored and we must all learn from one another. This is a working conference. It will be short on speeches and consist primarily of panel discussions and breakout sessions. There's one additional feature of the conference that I would like to mention. During breaks at various times over the next 2 days, Fordham Law School students will be conducting a survey of conference participants. They will be asking you questions about legal services organizations, funding, and initiatives in your respective home countries. I hope you will answer their questions frankly and fully. The survey results will be communicated to you and should help to extend the impact of this conference beyond this Saturday. A conference such as this does not simply happen. It requires careful planning and presents a host of logistical problems. Fortunately, the association has not had to shoulder that burden unaided. We have 4 co-sponsors: the Global Public Service Law Project with New York University School of Law, New York Lawyers for the Public Interest, the Public Interest Law Initiative and Transitional Societies of Columbia Law School, and the Stein Center for Law and Ethics at Fordham Law School. The planning committee was co-chaired by James Brum, chair of the association's task force on international legal services, Alan Rocker, the principal author of the 1996 Civil Justice Crisis Plan adopted by the association, and Joan Vermeulen, executive director of New York Lawyers for the Public Interest. Maria Imperial, the executive director of the City Bar Fund, who supervises the many public service and pro bono programs of the association, has made major contributions to the preparations for the conference. And finally, the secretary of the planning committee, who assisted many of you in making travel arrangements and finding lodging in New York City, is Dennis Cariello, the association's presidential fellow. Dennis's office is across from mine, and I can attest that he has devoted hundreds of hours to assisting in all aspects of the conference planning I think this has been a good experience for Dennis because he is not married, but when he does marry and has children, he may be able to deal with the stresses better than me. I thank you all deeply for participating in the conference. I hope you will leave here believing that you have profited by attending. And now I will turn the microphone over to Phil Alston, Chair of the Department of Law at the European University Institute in Florence, who will moderate the opening plenary session.
Thank you very much. Thank you very much. This morning I got a message on my answering machine asking me if I would send a copy of my resume to the people who are hosting a diplomatic dinner next week sometime, because they needed to know where I should be seated. In other words, they would evaluate my resume to decide how close to the important people I should be. When I evaluate my own resume, let me say I have no right to be chairing or moderating a session with such eminent exponents of the art and practice of access to justice. I'm Australian by origin. The very first time I left Australia was actually to attend a conference called Legal Aid and the Law Student, which was held in Singapore, as I recall, in 1970. And it was a great experience. There were law students from all over the Southeast Asian area. And on the final day of the conference, we had the great pleasure of the Attorney General of Singapore addressing us. We spent much of our time looking at the US experience that Justice Johnson, of course, was so central to. And the Attorney General of Singapore said, now, it's very important for all you law students to understand what's happening in the United States. It's good that you've had a week to talk about it. Don't make any mistake of thinking that these sort of ideas are applicable in our region. And I want to say to the Singaporean students that the clinic that they're talking about will not be going ahead. Thank you very much, ladies and gentlemen, for your attendance at this conference. That was the beginnings of a growing, or gradually growing, awareness in far-flung parts of the globe of the central importance of access to justice. I just want to mention two recent activities that I've been involved with, which have highlighted the importance. For some 8 years, I was the chair of a United Nations committee dealing with the unfortunately obscure subject of economic and social human rights. In that context, we discovered, of course, that these are the rights that governments will go to great lengths not to make justiciable in the first place, so that if you have such problems, you won't be able to get near a court. But where we discovered much more admirable and progressive approaches, they were normally precisely coupled with the inability of those who were most in need, of the vulnerable and disadvantaged, to get their cases into court. And very little was ever done to facilitate their access to justice in relation to the issues which most concerned and affected their very livelihood. On a more lavish scale, the European Union, of which I'm now at least a resident, being still, of course, an alien in the European Union, I had the privilege last year of finishing a very major study on human rights within the context of the European Union. And the conclusion drawn by a group which included Mary Robinson, the current UN High Commissioner for Human Rights, and various other distinguished experts in the field, was that the European Union actually lacks a coherent and even serious internal human rights policy. It's very good at pronouncing its external policies, but when it comes to human rights within the community, it tends to say that that's not a matter which should concern it directly. But where there is a violation of human rights by the European Union, the various procedures and institutions that our group put forward were completely unnecessary, said the European Council. Why were they unnecessary? Because anyone who had such a problem could simply go to the European Court of Justice and get their rights vindicated. Going to the European Court of Justice is about as easy as going direct to the US Supreme Court. So again, within the European Union, the idea of taking up the results of the study that we undertook in terms of access to justice within the community, particularly for poorer citizens or groups representing disadvantaged people, it was almost impossible to get a judicial hearing, but the union's official position still was to fall back, no, the court is there, that is sufficient. And various specific proposals to facilitate an access to justice approach were clearly rejected. I think it's clear then that no matter what context, whether it's a very rich society like the European Union or very poor society struggling with very different issues, access to justice is absolutely central. The agenda that we've got in the next few days provides a marvellous opportunity to explore the possibilities that might exist in the future, the phenomenon of globalization, the opportunities for a greater commonality of action, and I very much look forward to hearing all of the contributions. This afternoon we have 4 speakers. They will speak for 20 minutes each, and I hope not more, because it would be nice to have time for a few questions at the end. The first speaker, appropriately I think, is Justice Earl Johnson Jr., basically Mr. Access to Justice. Justice Johnson started in the mid-1960s working with Ford Foundation-sponsored neighbourhood programs, became the second director of the Legal Services Program of the US Office of Economic Opportunity, precisely the programs that my young colleagues and I spent so much time admiring and debating 30 years ago in Singapore. Then drafted the first version of the Legal Services Corporation Act of 1974. If he was Australian, I might suspect that he'd been appointed to the bench in order to take him out of all of these troublemaking access to justice activities. But if that was indeed the case, since his appointment in 1982, he's proved to be irrepressible and continued to be very much at the forefront of a wide range of activities in relation precisely to access to justice. So it's a great pleasure to welcome him and invite him to address you.
For that kind introduction. I had not anticipated that Mr. Cooper in his welcoming remarks would provide such an excellent synopsis of my own speech today. As he mentioned, in 1997, Judge Robert Sweet asked and then answered a fundamental question. And I quote, "What needs doing to help the courts maintain the confidence of the society and to perform the task of ensuring that we are a just society under a rule of law?" Judge Sweet answered, to shorthand it, "We need a Civil Gideon. That is, an expanded constitutional right to counsel in civil matters. Lawyers and lawyers for all are essential to the functioning of an effective justice system. No one could say it better, but we can say it longer. There is some irony in the fact that last year, Judge Sweet's own former law firm, where he spent his pre-bench career, earned 3 times as much as the entire budget of the Legal Services Corporation. Some indication of what it means that the U.S. still lacks a right to counsel in civil cases. $1 billion for a single law firm to represent maybe 100 or so corporations, while the federal government was only willing to spend $300 million on legal services for about 40 million poor Americans. Even adding in IOLTA and other federal, state, and local funding, the most recent LSC annual report finds that American governments in total, including LSC and all of it, are supplying less than $600 million for civil legal services. There are a half dozen law firms in this country, each of which took in more than $600 million that our governments, federal, state, and local, now spend on legal representation of the poor. Now, I want to be clear. I am not criticizing these law firms for being prosperous, but I am criticizing our government for being penurious. Not just penurious, but penurious about what Reginald Heber Smith called the cornerstone of American democracy: equal justice for all, irrespective of means. Before venturing beyond the shores of the United States, I would like to pass on a couple of other disturbing comparisons. At its peak in 1981, the LSC budget, then $321 million, represented less than 1.5% of the $23.7 billion the people of the United States spent that year on lawyers. That's a little over 1% of the nation's expenditures on lawyers to provide legal representation for nearly 20% of the population. But now, 2 decades later, the combined governmental expenditures on civil legal services for the poor, $600 million, represents only 0.5% of the more than $130 billion the nation currently spends on lawyers. Not exactly progress. From an inadequate 1.3% to a dismal 0.5%, a precipitous 65% decline in the poverty population share of the nation's legal resources. Nonetheless, $600 million may sound like a lot of money to an American audience, and especially to legal services advocates accustomed to seeing civil legal services treated as a third-class afterthought to the justice system, rather than the essential and integral component it is. Yet $600 million is a vast improvement, only in the sense that a $5 bill seems like a fortune to a homeless beggar who has grown accustomed to nickels and dimes. In my view, we will never have adequate government funding of civil legal services in this country unless and until we have a sea change in our view of what adequate funding is. When I first began researching civil legal services in other countries in 1973, I was only a few years away from my experience as director of the Legal Services Program of the Office of Economic Opportunity. While there, I had seen the OEO Legal Services Program increase this nation's investment in civil legal services for the poor by 8-fold, from the $5 million it had been for the entire country under charitably funded legal aid to over $40 million in federal funding, which is like about $120 million in current dollars. So I approached our research into other countries' legal services efforts with a typically chauvinistic attitude, as most Americans would. When I started looking at other legal aid systems, I assumed it would turn out that we were well ahead of other countries when it came to providing lawyers to those who couldn't afford their own. That what I found, I should say, was an eye-opener. Let me begin with the legal guarantee, what we call the right to counsel, where our country has had a guaranteed right to counsel in criminal cases since 1963. As was pointed out earlier, there is no such right in civil cases. The first shock I experienced when I began researching other legal aid systems was that somehow other nations also committed to democracy had recognized the critical importance of equal justice and assigned it a much higher priority. Early on, I learned about the rather primitive right to equal justice that came over to America from England, along with the rest of our common law legal system, the Statute of 1495, the Statute of Henry VII. And I also learned about similar statutory rights to counsel in many other countries. But as my research carried me beyond Europe, beyond England and the common law world, I was even more astonished to find that the interpretations our courts have accorded our constitutional due process and equal protection guarantees stand in sharp contrast to the treatment similar constitutional language has received at the hands of the high courts in other countries. In 1937, over 60 years ago, and a quarter century before our Supreme Court decided Gideon v. Wainwright, a poor person asked the Supreme Court of Switzerland to rule whether indigent Swiss citizens have a right to free counsel in civil cases under that nation's federal constitution. The Swiss Constitution contains a guarantee that, quote unquote, all Swiss are equal before the law, not unlike the U.S. Constitution's guarantee its citizens will enjoy equal protection of the laws. In a case entitled simply Judgment of October 8, 1937, the Swiss Supreme Court concluded poor people could not be equal before the law in the regular courts unless they had lawyers, just like the rest of the citizens. Consequently, it held the governments of the cantons were required to provide free lawyers to indigent litigants in all civil cases requiring, quote unquote, knowledge of the law. Similarly, in a decision of June 17, 1953, the German Constitutional Court also has made it clear that that nation's constitutional guarantee of a fair hearing in civil cases may require appointment of free counsel for poor people where the legal aid statute doesn't. But the Swiss and German right to counsel decisions pale in significance to the 1979 decision of the European Court of Human Rights called Erie v. Ireland, also referred to below. This landmark opinion emerged from the case of an indigent Irish woman who sought judicial separation from her husband. Now, the European Convention on Human Rights and Fundamental Freedoms does not guarantee indigent litigants a right to free counsel in so many words. All that Article 6 of the Convention does guarantee is that all civil litigants are to have, quote unquote, a fair hearing. The court held that no litigant could receive a fair hearing in the regular courts without a lawyer, and consequently, the member governments must provide free counsel to those unable to afford their own. But it is in the course of its opinion in the area that the European Court of Human Rights issued an unusually powerful statement about government's affirmative obligation, any government's affirmative obligation to provide equal access to justice for low-income citizens. It said, "The convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. This is particularly so of the right to access to the courts in view of the prominent place held in a democratic society by the right to a fair trial. The court concludes that the possibility to appear in person without a lawyer before the trial court does not provide the applicant with an effective right of access. The Irish government maintained that in the present case, there is no positive obstacle emanating from the state and no deliberate attempt by the state to impede access. The alleged lack of access to the court stems not from any act on the part of the authorities, but solely from Mrs. Airy's personal circumstances. She's poor, a matter for which Ireland cannot be held responsible. The court does not agree. In the first place, hindrance in fact can contravene the convention just like a legal impediment. Furthermore, fulfillment of a duty under the convention on occasion necessitates some positive action on the part of the state. In such circumstances, the state cannot simply remain passive, and there is no room to distinguish between acts and omissions. The obligation to secure an effective right of access to the courts falls into this category of duty. Now, unfortunately for the poor of the United States, in a 5-4 decision filed just 2 years after Airy, Lassiter versus North Carolina, the U.S. Supreme Court held constitutional due process is satisfied in a civil case even though a poor person lacks counsel. So, the constitutional right to a fair hearing in Europe requires government to provide free counsel to poor people in civil cases, but the constitutional right to due process in the United States does not impose such a requirement. Somehow, legal representation is essential to fundamental fairness in Europe, but not in the United States. Remarkable people, these Americans. They all come with a law degree, evidently. Turning from the legal entitlement to counsel to the level of government investment, it undoubtedly would come as a surprise to the average American, not necessarily to the people in this audience, to learn where we rank compared to many European and British Commonwealth countries when it comes to public investment in civil legal services for those unable to afford counsel. England, with a population of only 50 million people, now outspends the United States in absolute terms almost 3-to-1, despite our nation's population of over 270 million people. The English government's net expenditure on civil legal aid is currently over $1.5 billion a year, while ours is at $600 billion. But it's when we look at per capita expenditures that the comparisons become truly remarkable. For the United States, the combined federal, state, local government investment works out to about $2.25 per person. That compares to the English expenditure of $32 per capita. If the United States government funded legal services as generously as, say, the major Canadian provinces, the Netherlands, New Zealand, or Sweden, it would have to spend in the range of $2 billion to $3.5 billion a year on civil legal services. But England represents a still higher league. If the United States government were to spend as much on civil legal services proportionately as the English government does, the annual budget would exceed $8.5 billion. This vast disparity in legal services funding puts the United States and England at opposite ends of a very broad spectrum. It also means we are at very different steps on the road toward a society which truly offers all its citizens equal justice. And thus we face very different problems. To borrow a health services analogy, the United States is in a triage situation, indeed one of extreme triage, trying to pick the relative few who will be able to offer a free lawyer. On the other hand, England, and to a lesser extent, some of the other European and Commonwealth countries, are in a cost containment mode. They are facing the problems the healthcare industry in this country might call managed care. That is, how to keep the costs down while continuing to give all their citizens the right to equal justice these nations endeavor to guarantee. I do not mean to suggest that all what I've said about the current state of legal services in the United States, that we don't have high-quality lawyers delivering high-quality legal representation for this country. No, the contrary. I continue to be amazed by the dedication, imagination, and professionalism of so many legal services lawyers, including those who appear before the California Appellate Court. In addition, they have become experienced practitioners of triage. In that sense, they have much to offer emerging democracies and developing countries that lack legal resources or resources in general. In a few cities, like New York, they also benefit from the generosity of the local bar, foundations, and other private charity to augment the government funding. But to the extent justice depends on charity, it also is destined to be unequal. To illustrate, because of an unusual concentration of private funding, the diverse array of legal services agencies serving San Francisco's 100,000 poor people have 4 times the resources per poor person as do those agencies serving the 2 million poor people in my home county of Los Angeles. You know, if the U.S. had public funding at the level of San Francisco does largely through private charity, we would be a lot closer to some of the European and Commonwealth countries I've discussed this afternoon. But we don't. Not even close. Which brings us back to Judge Sweet and his call for a Civil Gideon in the United States. It is time, past time, that the United States, its government, and its court join the growing international consensus that words like due process, fair hearing, equal protection, and equality before the law express a universal principle, a right to equal justice that is to be enjoyed by everyone. And as the European Court on Human Rights pointed out, if that right is to be practical and effective and not merely theoretical or illusory, for those unable to afford counsel, it must include the right to a lawyer supplied by government. So when someone asks, what is equal access to justice? I would answer, that's what it is. Certainly a necessary, but not necessarily sufficient condition, a guaranteed right to counsel in civil cases. And if they asked, why is it important? I would answer, because without it, a nation's poor people are less than full citizens, and that nation is less than a true democracy.